Very warm welcome to everybody. Thank you very much for joining the webinar today. It is a great pleasure to have everyone on the call today. So this call is being hosted by Oxfirst. Oxfirst is an economic consultancy specialized in intellectual property and competition law. And we were formed out of the University of Oxford, and our strong interest is in the valuation of patents and copyrights and in front royalty rate calculations. And we have testified many times all over the place on the value of a front and what is the value of a front rate. And we have also done a lot of economic assessments on injunctions and public policy issues in general. And I prefer to say this now because a lot of people said to me, we had no idea. We thought you're just a professor and you don't really do anything else than research. And other people said to me, we thought you're only an event organizer. So I thought it's important to explain that. We do events and I love research, but at the moment we do a lot of expert testimonial in legal proceedings. And we're working also on the public policy side relating to economics of IP. Another really important element to say is that we are running a conference again. We have been invited by the University of Oxford, and we'll be working together with the School of Law of the University of Oxford on our event in January, most likely, discussing IP and competition matters. And we are also working on a second event in summer, our annual event, where we are most likely going to be in Amsterdam. So please get involved. We'd love to welcome you in Oxford or in Europe, or ideally in both locations, where we will chat, debate, and discuss on the value of IP, on recent judgments, on where the Unified Patent Court is heading, and what on earth the value of a front rate could be. So with all of that being said, I would now like to introduce our speakers, Dr. Andreas Kramer from Vossius Brinkhoff, operating as Vossius in Germany and as Vossius Brinkhoff, I understand, under the Unified Patent Court. And Andreas is a very experienced litigator who has done a lot of front cases and is quite knowledgeable in this area. Alexander Hertel is the cluster head of intellectual property for Deutsche Telekom and responsible for Deutsche Telekom's quite extensive patent portfolio and patent strategy and intellectual property strategy in general. And before that, he was also in private practice and for many, many years a partner with an equally well-regarded law firm in Germany. And Philip Nastenbowski is also a partner. He recently changed law firm, and Philip is actually a graduate of the LLM program at the University of Edinburgh, where I used to teach for many years. So I'm very proud to see our grads and alumni having such a marvelous career as the career that Philip has, quite frankly. Shows that our teaching was not in vain, makes us all happy. The topic that we wanted to talk about today is one which I think is quite hot. So what happened was that the European Commission intervened with an amicus brief in German court proceedings. That is interesting for a whole bunch of reasons. We gave a very honestly boring title to this webinar. And I thought you couldn't have described it in a more boring way, because we thought that's a way to keep it neutral. But nonetheless, the people who know, and we got 150 or 160 people actually sign up to this, even though I kept it as sad, as uninteresting as possible as an advertisement. And I mean, the issue is hot. First of all, amicus briefs are not really common in Germany and in Europe in general. This is more a US thing. So we are now referring to US habits in European proceedings. That's the first thing which is exciting, and that the European Commission competition authorities get involved and give their opinion on a German case. We already see in other areas of France quite an elaborate dichotomy, I would say, between the judges and the European Commission. So we see, is this a further polarization where Brussels is heading, where the judges are heading? And the most important question everybody has been talking about, will it change anything? Will the German judges listen to European Commission's opinion, or will it just be read and taken note of and be put on the shelf and we thank you very much, and that was it? So our experts are really very well prepared to discuss these matters and to give their opinion on how they see Germany's relations with the Commission evolving on this whole thing. So first of all, can you please give the audience an overview of what this Amicus Brief is about and what are the key points that got your alarm bells ringing?
Well, thank you, Roya, for the kind introduction, and thank you for having us as panelists for this exciting topic. Let me briefly start off the discussion with an overview of what this Amicus Brief really is. So you've already touched upon the topic that it's extremely rare. And it's more of an US thing. It's so true, because I've looked up the statistics a little bit of how often such an amicus brief was filed in European national court proceedings, and it's increasingly rare. It's 20 cases since 2006. So a lot of countries have never ever received such an amicus curiae brief. For example, France and the UK, they have received 5 of them. Dutch, Slovakia, Germany, 2 each. Austria, Belgium, Spain, and Hungary, 1 each. Well, the UK won't be getting any amicus curiae briefs anymore, so they are out of that. And mostly it concerns like cartel damages, price fixations, and so like classical antitrust topics. As far as I know, there's no real technical IP. There's one which relates to copyright in a sense, but that's only related. What is the sense of such an amicus brief? An amicus brief, if it's issued by the EU Commission, aims at the uniform application of EU law, or rather, as in this case, the uniform application of case law. The EU Commission is of the opinion that the courts in Mannheim and Munich apply the logic that was issued in the Huawei ZTE case, which is almost 10 years old by now. It dates from 2015, varies, it differs. And therefore, the EU Commission thought it was necessary to issue this amicus curiae brief to give some guidance on how this EU case law shall be interpreted and applied by the national court. In doing so, it highlighted a few things, and we'll just give you a very short run through, and then we'll go over in the detailed discussion. So as you may recall, the Huawei ZTE judgment gave like a front down. So there is a first step, which is the infringement alert. And the EU Commission said, okay, in order for this infringement alert to be valid, it must follow a few procedural rules. It must contain some elements. And after that, there is the willingness declaration. That also, from the EU Commission point of view, is a more formalistic point of view. And then there is nothing in this amicus curiae brief, because the dispute between the parties was limited to the first 2 steps. If you recall the steps that the Huawei ZTE decision was providing, there's a 3rd step, which is the friend offer of the patentee, the 4th step, which is the counter offer or refusal. So it's still, there is more to come in a sense. So, but having that outlook, and maybe one more general mark, what is, if you look at this amicus brief, I think the word most frequently used is sequential. So the EU Commission highlights that it is utterly important to maintain the sequence of the steps and not to mix these steps. But we will come to these issues in a moment. So let us have a first look at the first step, the infringement alert. So Andreas, Philip, what is new there? Is there any new elements that we need to be aware of now?
Yeah, well, I'm happy to start. Well, thank you, Roya, for the introduction, and thanks for also having me here on this webinar, and thanks, Alexander, to make this introduction here. So with regard to the infringement alert, the first step, so what is new? What is the European Commission's observation on this? So in summary, it is that everything has to be in the infringement alert. So if there is a letter, the patent has to be named, the infringement has to be determined likely by referring to at least specific passages of the standard. And what is most important is that the European Commission tells us what shall not be admissible, and that is to merely refer in that letter to a website, for example, of the patentee. And that is what happened here. So there was a letter, and in the letters it was said, well, you know, more information on the portfolio, on claim chart, etc., can be found here. And then there was the link to the website. So the European Commission is a bit formalistic here in saying, you know, it has to be in that letter. And also the letter has to be filed for the complaint. However, also here they leave the door open to a, let's say, the German practice. What we have seen oftentimes in German litigation is that patentees start off with infringement complaints that do not include injunctive relief from the outset, but only damages and claims for information. So here they say, you know, that could also serve as an infringement alert. However, what shall be not admissible according to the European Commission would then be to start with a complaint with injunctive relief without having prior contacted the implementer. So that is what we have seen in German litigation several times, where really the first contact between the patentee and the implementer was via the infringement complaint, including injunctive relief. So here they are very clear that this shall not be admissible. What also has to be highlighted is that, and we will discuss this, I guess, a bit more in detail when it comes to willingness, is a clear cutoff date. So the European Commission holds the view that everything needs to be done before filing the complaint, and that you cannot make up for this in the course of the litigation. So the cutoff date is the filing date of the complaint, and if you have missed your obligation, you have missed it forever for that proceeding, which is not that much of an issue with the infringement alert and the patentee, so they can just withdraw and, you know, make up for this, file a sufficient infringement alert and file again. But it's very different for the implementer. But I think we will discuss this when it comes to the willingness point.
Yes, thank you. Philip, anything to add to that infringement alert from your perspective? Anything that we need to be aware of? What changed?
Yeah, not so much with regard to the infringement alert. That's correct. It's a formalistic approach that they want to see basically a clear alert, hint to the patents that are infringed, in which way they are infringed, basically as spelled out in the Huawei ZTE decision. I think the core of the Amicus Brief lies actually with step 2, the declaration of willingness. So what's in there? So basically, what the Commission is saying, that this willingness was, in the Commission's understanding, not phrased in a friend way, in the way of the Federal Court of Justice, but there were like conditions in this willingness declaration. They said, yeah, well, we will take a friend license, but also only to patents that are valid, that are truly essential to the standard and enforceable. And you might take from the Amicus Brief that the Commission is unhappy that obviously, in particular, the District of Munich considered that as insufficient to accept that as a willingness declaration. However, I think this is not fully the core of the amicus brief, because in one paragraph, and I think this is the decisive paragraph, the Commission states that all steps of the friend dance have to be performed before the complaint or the action for the injunction, the request for the injunction, recall, and destruction is filed. All steps, including the infringement notice and the willingness declaration, but all steps also meaning the first offer of a friend license, the offer meaning the offer of the SEP owner, and the reaction of the implementer should be discussed before this action for injunction is filed. And I consider this the core of the amicus brief, because the Commission states in several instances that from the Commission's understanding, it was the aim of the Huawei ZTE decision to have at this in negotiations without the pressure of an injunction looming with regard to the implementer. And this is probably core of the issue, in my understanding, that the Commission is wanting to have a pushback for the claim for injunction, and wants to have this pressure-free discussion. And this is something one can discuss. Is this really making sense, or is this a formalistic approach in that sense, if you look at the cases and the facts of the cases in hand? But we will discuss this in more detail, because in the end, you have to see that this is touching on a case that started in 2019, the first contacts. Parties have negotiated for over a year. Then the action for information, rendering of information, and the DJ of damages, the claim to DJ of damages was filed sometimes in 2020. Parties continued to exchange offers to take a license, and only in 2021 the action for injunction was filed. So there was a negotiation going on, and then this setup clearly is up for discussion if it's necessary to have such a formalistic approach in this setup as is at the hand in this case here.
I think you're right in this, but the amicus brief very much clearly says in the very beginning that it is not intended to evaluate or review the behavior of the parties in the specific case. It just uses this case, let's say, as a vehicle to opinionate, to put out that opinion on how that case law of Huawei should be applied. And it occurred to me when I read the amicus brief that, as Andreas mentioned, the first step that can be rectified if you erroneously filed an injunction complaint first, you can withdraw it and file just the rendering of account and declaratory judgment for damages first, so that you have your valid infringement alert. But if the plaintiff was like super fast and do this and not make a timely wait for the potential licensee to declare their willingness and just go ahead and file that injunction, then I read the amicus brief that may be a bit problematic for the implementer, because that cutoff date, as we had already discussed, it prevents the implementer from like issuing this willingness at that point anymore. So the patentee would be in a safe harbor, because okay, his first step would be completed thoroughly, and the patentee would have then the second step missing. So I think from logic here, it would be right to say, yeah, actually step 2 should be completed before you apply for that injunction. But I don't see that all the steps need to be completed before you apply for the injunction. They should be, because that's the intention of Huawei, but doesn't say so, I think.
Yeah, just one further comment. Yeah, I would read this in this paragraph 68 in particular. However, I think what is the really what is bothering the Commission in that sense is that the definition of this willingness step is, and this is why they sent the Amicus Brief to the Appeals Court of Munich, even though they could also have sent it to the Appeals Court of Karlsruhe, right? There's a parallel case pending, but they sent it to Munich because I think the Commission's concern is that the District Court of Munich made this connex between the original willingness to license, but then assess the willingness to license on the basis of the counteroffer of the implementer and their conduct during the proceedings after the complaint for injunction has been filed. And this is the connex which I would say the Commission wants to, in their view, want to rectify, that the willingness is, from their perspective, a formal step for the implementer that should trigger the friend offer by the SEP owner, by the ZEP owner. And this shortcut that in particular the District Court of Munich is choosing to jump into the behavior of the implementer is something that the Commission is willing to or is interested to have been clarified from higher case law and maybe with a referral to the European Court of Justice.
I think, if I may, I think it's two issues. The one issue is the cutoff date, and the other issue is the strict sequential order that the European Commission favors. The sequential order, that reminds me of the Düsseldorf case law, you know, that differentiates between abstract and concrete specific willingness. And the cutoff date issue, that reminds me very much of previous Mannheim and Karlsruhe case law. And I'm a bit wondering why they haven't referred to that case law that was then decided by the Appeal Court of Karlsruhe. And if I may, because I was involved in that proceeding, I can refer to that, how this developed in terms of case law. So back in 2016, there was this approach of the Mannheim court, as with the European Commission, in holding that the cutoff date is the filing date. So, and that really makes a big difference between the patentee and the implementer. So that specifically was decided in the Vico versus Philips case, where in the first instance, Vico was held to be an unwilling licensee. Why? Because the first instance court held that their response was delayed. So their response to the infringement alert was received, it was sent before the complaint was served, but only received a few days later. So, and then afterwards, so what Vico did is they made good for this, they filed, they made a counter offer, they provided a security, they provided information on sales figures and so forth. And nevertheless, the first instance court ignored that. They said, well, it's a cutoff date. Once unwilling, you will stay unwilling, and that's it, game over. Obviously, this was appealed to the Karlsruhe Appeal Court, leading to a decision in October 2019 that then set aside this case law. And they cited with the arguments that we made that it is grossly unfair to the implementer, because the implementer, cannot make good for this in the course of the proceedings, and then the reason why they set aside the previous case law was that they said, well, yes, we agree it would be, disproportionate, and that is a fundamental principle of EU law as well, if you would not take into consideration the conduct after filing of the complaint. And yeah, so that was the issue here. And then they said, so you can make good for this. And in that case, they then considered Vico to be a willing licensee, and then referred, and then we're back with the sequential order, and then they had to look at the offer of Philips, and then they said, well, but this offer was insufficient because they did not provide sufficient information. So that was overturned on appeal, and at the same time, the appeal court made some suggestions as how to deal with the situations in which the one or other party fulfills its obligations after filing. And it says, if the patentee makes good for its obligations, then it has to agree to a cooling off period. The parties have to agree to a stay of the proceedings. Then they can negotiate for like 6 months or so without the imminent pressure of an injunction, and move ahead. And if that is not successful, then the proceedings will continue. On the other hand, the implementer can also not fulfill its obligations, shortly before the hearing. Then it will also not be considered to prevent delaying tactics. So there was, a suggestion by the Karlsruhe court as to how to deal with these scenarios. And I would have expected that the European Commission at least touched upon this issue, to be honest.
So Roya is already adding the poll that the question is, will the amicus brief change anything? So that nicely leads to a discussion of all the consequences. So we've heard already a little bit on the German background, what kind of specific case law we already had, but how will this continue? What will the impact be? What I can add here is that, as far as I'm aware of, the hearing at the Court of Appeal in Munich is scheduled for October 31st. So we will have a decision on that issue probably, let's say, a few weeks later. So probably there will be quite a bit of audience in the room at that time. So a lot of social media posts going around after October 31st, how this will develop in the future. But what's the likelihood of the outcome? Will the Munich Court of Appeal refer that case to the CJEU? What do the two of you think? I mean, from a purely academic point of view, I would always prefer, okay, let's have that opinion from the CJEU just to get some clarification on how that case law should be applied. But what do you think will happen?
Yeah, let me start on that question first. What will happen? So a referral to the European Court of Justice would be possible under Article 267. The question is now if the Court of Appeals in Munich will pose these questions. First, we have to consider that the Court of Appeals in Munich doesn't have to do that because it's not the last instance in Germany. That would be the Federal Court of Justice. So they are basically under no pressure to decide this. And the question is, do they see this question essential to decide the case? Will they want to refer this to the European Court of Justice because they also see that there is something maybe be corrected or further clarified by the European Court of Justice? I currently don't see this point because in the end, again, I would say the Commission is looking for the sequential order, and where the Commission is aiming at is that after the declaration, the formal declaration of willingness, the SEP, the ZEP owner, makes his friend offer. And I personally think the Commission is aiming at that this friend offer is reviewed more properly by the courts, rather than jumping directly on the behavior of the SEP owner and looking in their counter offer and saying this is basically an expression of delaying tactics. They want to put more assessment of the ZEP owner's friend offer, just than saying, oh, this offer is not blatantly unfriend, so we don't have to review that further. However, there's nothing in the Huawei ZTE decision referring to what is friend. Also, the European Court of Justice wants to leave the determination of friend terms to the parties. They provide a set of rules how the front ends should ideally work. So I'm not sure if the Court of Appeal of Munich will refer these questions. I mean, we have a new presiding judge at this court. I've looked it up. He had made one referral in 2014 regarding trademark law, but since then he has been rather quiet on that. And there's another instance. There has been already an injunction in the interdigital Lenovo case, I believe, from the District Court of Munich, and they applied for a stay of the enforcement proceeding, which goes, of course, to the Appeals Court of Munich at a time when this Amicus Brief was already known to the Court of Munich. So they would have had a chance to refer the case already then, or at least stay enforcement, and they didn't do it. So I would say by all likelihood, it's rather unlikely that the Court of Munich, who doesn't have to refer under Article 267, will make this referral at this current stage.
Mm. Quoting from a judge from a previous proceeding that I've attended a number of years ago, was it known to the Court of Appeal in Munich in that specific case or not? So sometimes courts are like not blind, but they are seldomly unaware of things that happen in other proceedings to be applied in specific proceedings. So if the parties didn't rely on it, I'm not sure they would respect it. But Andreas, just going back to you on that question, what do you think are the chances are? I mean, if the Munich Court of Appeal would not refer to the CJEU, would the Federal Court of Justice then do it? Because if I recall correctly, the Federal Court of Justice is more of the opinion that you can mix the steps and you need to evaluate the behavior throughout all the negotiations. So that amicus brief more or less targets the FCJ case law more than maybe the Mannheim and Munich case law.
Yeah, exactly. I mean, that is a good question. So the European Commission invites in particular the Munich Appeal Court to refer this to the CJEU, and obviously they're not obliged to do so. Whether it will be decisive in this specific case, I don't know. That is also the issue. I can also imagine that they will, leave this to the Supreme Court. Citing with the first instance Munich judges that say, well, we feel to be in good company, namely with the Supreme Court. And that is why we have this approach that we believe is in line with the Supreme Court case law that guides us. So I can very well imagine that scenario here.
But isn't it much more unlikely that the Federal Court of Justice will refer it, because it would be in contrast to their case law? I mean, if Meinhardt want to change anything, he should take it up himself to the CJEU and not leave it over to the Federal Court of Justice.
Yes and no. I mean, on the one hand, we also have a new presiding judge with the Supreme Court. I don't know whether this makes a difference. And I would also doubt that the Supreme Court has sufficiently answered all questions yet. So it might become a decisive factor, and then it should, and it's the final instance, it needs to be referred in my view. And I'm also saying this because I would not necessarily say that what the Supreme Court has decided in Sisvel Higher is or contradicts what Düsseldorf has done previously. There's always a saying that they heavily disagreed with the Düsseldorf court, but I don't know. There is a construction of that would align both case laws. If you refer to Sisvel Higher, what were the underlying facts? The underlying facts were that Higher was considered to have made undue reservations, namely that they will only take a license if the patents are infringed and valid with final effect. So that is in fact what was the factual basis for the Supreme Court to decide this. And if you refer to this, it takes like 10 years or so. We all know this until there is a final decision of a court. If that, if that is considered delaying tactics, and that might even be sufficient to deny the abstract willingness that is, the key element in the Düsseldorf case law. And if you would consider Sisvel Higher to already having denied abstract willingness, then the Supreme Court would not have decided the scenario in which an abstract willingness was given and where the specific willingness needs to be assessed. So it's not necessarily that really it contradicts, I would say. Yeah, so we will see.
So is there any result already to the poll of the amicus brief change anything? Just wondering.
Yes, there is. The vast majority of the opinion, it's not going to change anything.
Okay, good.
60% of people
60, okay.
are saying nothing will change.
Mm-hmm.
Well, a bit like, will the German judges listen to this question? There we have nearly 50-50. 53% say no, 46%, 54% say no, 46% say yes. But generally, will it change anything in Germany? No. Which brings me to a question. Philip and Andreas, Philip is with Eisenfuhr and Speiser, and for Andreas with Vossius, and the way I have met both law firms is that they tend to represent a bit both sides on a different spectrum. And for downstream innovators and for companies pursuing SEPs licenses, in your opinion, what are the implications under each of these scenarios that the amicus brief is heard of? Will that harm the ability for SEPs licensing? Will that be not so good for the SEPs owners? Or how does that look like for the implementers? Or is that amicus brief by and large neutral, no matter where you stand in that question?
Well, if I may start, so the amicus brief as such does not change much. Mm-hmm. The question rather is, what can we take from this? And I think what we can take from this is there is great uncertainty and vagueness, because the European Commission and the Munich courts, the Mannheim and Karlsruhe court, and the Supreme Court, they all apply the Huawei ZTE case law in different ways. So, and each court is convinced that it construes this the right way. But the ways differ, and as a matter of fact. So I think what is needed, and what is more or less urgently needed for quite some years now, is clarity on this. And so in any event, it would make sense to refer a lot of questions to the CJEU. And if the Munich court would consider this, they would not have that much work to do, because the willingness questions, for example, they had already been referred to the CJEU, namely in the Nokia Daimler litigation. They were not, and the questions were, along the Düsseldorf case law, and there was a justification for this. Well, basically confirming the Düsseldorf case law, so explaining why the court, the district court Düsseldorf here, Judge Kleps, why she and they believe that it should be answered the way they have explained this in their justification. So, and that clarification is still missing. So these questions should be refiled with the CJEU, and other questions should be added, I guess.
Mm-hmm. I would agree with Andreas. It's basically not the questions that seem to be raised in the amicus curiae brief. They will not change much. If that comes to the Federal Court of Justice, they will probably say that's an act clear. The friend dance is set out, and the interpretation of the friend dance is up to the national courts. And hence, this is what we've done with friend 1 and friend 2 decisions in 2020. So no reason for that. But the questions that are open are actually different questions. As Andreas said, the question prepared by the District Court of Düsseldorf regarding suing first, second, third tier suppliers, questions of license to all or access to all, which to sue first. These are the imminent questions. And the other questions would probably, what could need clarification is the sequence of steps. So if you really would say we have to review the offer from the ZEP owner first and have it clear to look before we jump on everything what the implementer does, I think that would be a more balanced outcome. I think what the Commission is always, this is my impression, is of the opinion that already suing for injunction would be an abusive behavior under Article 102 of the European Treaty. But in fact, it's not. The implementer can use the patent for quite some while without having to pay a license fee. It's only the injunction that will be handed down somewhere at the end of the proceedings. And from this position, the German position just provides like a framework and a time frame where people can negotiate. And it's, I think, the more flexible and more adequate to the facts approach by the German courts to say you have now about the time for the first instance proceedings to get closer to a friend agreement and use that time. And of course, the implementer has to play by the rules in this time frame. And again, everybody is wondering why the friend defense is not working. But when you look at the facts of the case, also in this case, they have a prehistory negotiation where we're going on for 1.5 years. This is a clear holdout tactics. I'm not sure if the European Court of Justice would judge these cases in a different way. So I think, if at all, the questions to the European Court of Justice would probably have to be phrased in a different way. But the Amicus Courier brief is unlikely to change anything in the moment. I mean, Alexander, you already know that from your practice. I think the way ZEP owners behave with their infringement notices, that has much more improved, and they are much more sophisticated. They play by the rules. Most of the time, ZEP owners already fulfill the formalistic steps of the Commission. So that would not change anything about the status quo, I would believe. So it's the question of whether the implementer is playing by the rules and how he is trying to hide its delaying tactics in behaving during the negotiation process. Right.
I think one of the points that you've mentioned, Philip, is that the indeed the infringement alerts have become better over the recent years. Better meaning more complete in a sense. So I think there's progress on that side, but also I think the implementers have learned how to respond to that. And I think the most intriguing question that I always have in this context is what you've already touched upon, is how that third step, how the friendness of the offer of the patentee has to be reviewed. That is left open with that amicus brief. So in a sense, one could say, yeah, that amicus brief didn't change that much, but maybe, and I think Philip, you already pointed out to that earlier, it may force, if applied, the courts to really review that friend offer, that third step, and hence it may make a whole lot of sense to refer this to the CJEU to order to get some clarification on how that shall be done. Of course, there's always, it's a question of each single case, what is friend and what is not, but like having a common sense of understanding how to review this and what needs to be done in order to complete that step. I think there's some guidance from the CJEU could be very much helpful. And that's actually when I first read that amicus brief, that is a bit what I was missing. It's sort of a cliffhanger. Get to the most suspensive part of the whole story of that friend dance, and then it just stops. Yeah, signature. Wow, perfect. So I think that would be really great. However, I fear that if that question would be included, I'm not sure if that would really be able, or if the Munich court would be able to refer this up to the CJNU, or if that is, but that's a question of procedural law.
Yeah.
But I think that brings us back to what Andreas said. I think that is the point where currently the courts in Düsseldorf and on the one hand, and Mannheim and Munich on the other hand, are a little bit, there is a dispute, or say a different approach with this abstract willingness and the concrete willingness with regard to the friend offer of the ZEP owner, which is followed in Düsseldorf, but not so much followed yet at the Munich courts. And this would be something that should be clarified. But if that has to be clarified on EU level or on national level is a different question, right?
Yeah, I mean, Philip, you mentioned the rules and that most of parties play by the rules. I would say, we still don't know what the rules really are. So, and the parties to some extent are guessing what the rules are. So there certainly clarification is needed. And I fully agree with Alexander on this third step and the fourth steps, and that is the offers. That this needs to be assessed, or we need guidance how this should be assessed. Because, I mean, let's face it, the overall shortcoming of the German courts is, irrespective of which court it is and what the specific approach is in terms of willingness and infringement alert, the main shortcoming is that they do not look into the front rate determination. There is no front rate determination. And I think that is the main issue. And I also think that the Supreme Court, when they cite the UK courts in, that the implementer has to take a front license under whatever terms are in fact front, this quote is to some extent misplaced in the Supreme Court decision. And why is that? Because German courts don't do this. If a UK court says you have to commit to a front rate, whatever that is, in the end of the proceedings, they will know. But in German proceedings, you don't know what this will be. So there is certainly further guidance needed. I also see that the court system is different. And what you hear a lot from German judges is that they say, we cannot handle this. How can we handle this? We have a certain amount of time allocated to each and every case. We cannot hear front for like 2 months or several weeks. That is not possible. And that is something that needs to be addressed at a higher level, I guess, to some extent. But does that mean that German courts cannot do what other courts do? I don't know. This question could, for example, be referred to experts. Why don't the German courts appoint an expert on this? And then this expert may be questioned by both parties. And then the court decides which approach is the right one. And that is what the UK courts also do. They side with the one or other expert and what is more plausible and what is more convincing. And even if the German courts do not have the time to look into this in detail from the outset and make up their mind, so why don't they engage experts? I never understood this. And we have said this so many times in court proceedings that is a feasible option. And the German procedural law provides for this, that this leads to some delay. Well, yes, likely it will. But what's the flip side? That German courts cannot decide this at all? I don't think that this is the proper outcome. So we need to have a balanced approach, I think, to also look into the details of the front offers that have been exchanged.
That's a good point. I mean, that's what's missing really, and I think that's the way to move forward with these kind of cases, that we have a much more precise look at what FRAND really is. I think maybe going to our next kind of idea was what are the strategic options that like implementers and SEP holders should be open to? How can they adopt to whatever is in this amicus brief, and what maybe courts in Germany will say? I think one of the points maybe not only having the German look, but also what will UPC proceedings, what will they look like if you look at this amicus brief? I mean, we come from the perspective that I've already mentioned that in German proceedings, the infringement alert could be substituted by a complaint aimed only at rendering of account and declaratory judgment for damages, and then adding later on the injunctive relief. Will that be possible also in UPC proceedings? I think there's some new developments on that.
Yeah, maybe I'll start on that one. Of course, we are all yet not quite clear. It's gazing in the crystal ball how the UPC will handle friend cases. Of course, there is some assumption that the German judges that migrated to the UPC will do what they've done, what they've always been doing at their local national divisions. So there might be an idea that they would apply a similar approach they know from the German district courts, also taking into account that the time frame for the first instance proceedings at the UPC wouldn't leave much more room for extensive friend negotiations and hearing experts on this point, as it is done in the UK proceedings, where you have friend hearings and technical hearings. This is probably not matchable with the rules and the timelines as they currently stand. However, I mean, the streamlined approach that has worked quite well in the German national proceedings that you filed for the DJ on damages and rendering of account first, and this is considered as the infringement notice. Then you get into the negotiation phase, and only one, so you don't get any further, you file the claim for injunction. It's questionable if that will work so easy before the UPC, because we have seen in a very recent case that it's not so, that it's a rather complex thing to amend your claim, amend your complaint and adding claims to a running proceedings, because you always have to explain why you didn't amend your claim in the beginning or at the earliest stage possible. And this is Rule 263 that clearly provides for that. And we have already one decision from the local division in Munich, referring to the Ericsson versus Lenovo Motorola case, where they said, yeah, well, you filed your claim for injunction in the UK in February, and now you're coming with your amendment of the UPC case only in May. That's too late. You cannot amend your claim. And Judge Segan, who was a presiding judge at the local division in Munich, he just said last week on a UPC user forum that this might be a difficult point to reconcile with this rule in the procedural rule. So if this German approach will work before the UPC is yet still open. So that may also something to take into account.
That might make SEP enforcement before the UPC a little bit more tricky in view of this step sequential view that the EC Commission is pointing out here. Taking a look at Andreas. Yes.
Yeah, I just wanted to add the UPC case though was certainly developed. So I don't know what really the specifics in Lenovo versus Ericsson were. It might make a difference if the plaintiff tried to drag the claims for injunctive relief into the existing schedule of the court, because the defendants will have to have their time to reply to this, and if that does not fit in the schedule, that might be an issue. but that could also be overcome for the patentees, right? If they would agree that the proceedings may be delayed and they would agree on a later hearing date, I could also imagine that there is some more flexibility with the UPC in how to deal with that, as the provisions are obviously addressed to safeguard the timing of the court. And if the patentee would voluntarily agree to have a later hearing date, I could imagine that there is some flexibility with the judges and how to construe the rules, I would assume.
So timing is a very good keyword, because I think we are nearing the end of the webinar and there are 3 open questions in the questions and answers. So I'll just pick out one.
4 meanwhile, 4.
4, now it's 4.
Yeah, now we
Sorry.
get more and more. Boom. Some of these questions are so complicated, I don't even know we can answer them in a few minutes. I would also like to just say, dear Philip, it's not that the German courts don't care about experts. I'm quite a bit involved in German courts as an expert at the moment and have already been in the past. And these are maybe not the same expert reports as in the UK, where you spend a year with thinking something, but it's happening. So people are also changing in Germany. So now, okay, please, Alex, really go ahead. There are lots of questions.
One of the question was on the expert opinion, as you just mentioned, Roya, and exactly that is what the draft regulation on SEPs wants to achieve. And if you look at the Huawei ZTE decision again, I think it's also in the Amicus Brief, there in number 54 states that if the parties do not get along on the price finding, they can ask a third party to determine the price and terms and conditions. So I think that's always a possibility, and that can be seen as the fifth step in a sense, because if step 3 and 4 do not match for whatever reasons, then maybe in step 5 one can have either the new EU IPO, PMAC, WIPO arbitration, whatever, determine a friend rate and terms and conditions. So that should cover that. So let me just go through. Philip, if a home builder demands twice the contracted price for 2 years before suing you and the court looks at the price and overruns, how is this not holdout? But in the SEP context, you say the licensee offers a friend rate, yet is holding out.
I'm happy to take this this question offline.
Okay. Maybe we can answer the question that Eric was posting in the very beginning, because when we were talking about the willingness, he says that does not strictly following the sequence mean that German courts will be forced to determine if the offer was friend before considering any subsequent behavior of the alleged infringer. I think that is about what we discussed. So that AC brief is just aiming at having more emphasis in these proceedings on review of the friend offer, and not too much into taking account that on that offer the defendant was like answering too late, whatever.
That will happen. You know, if the threshold for willingness is not that high and it's rather formalistic, then this is what will happen. Then the offers will have to be assessed, and then you will not be facing scenarios where it would be simply left open. And because, I mean, it might be a rhetorical question, but can you injunct an implementer that has made a front offer? I don't know. And if that is, I mean, the question is quite, the answer is quite obvious. But then if there is a counter offer, then there is a need to have this assessed. And the same holds true for the offer of the patentee, obviously. So both offers have to be assessed. And you know, if both offers are within the front range, then we might have to again refer to the CJU. You know, what is the consequence of that? Will the patentee prevail that has not breached antitrust law, or shall there not be an injunction because there was a front counter offer? And if the front counter offer, you know, if this would not have to be looked at? Why has the CJEU mentioned that there is the opportunity to make a counteroffer? So there are many further questions, follow-up questions to be referred to CJEU. And
just on this point, I think that would be the correct question, how you assess the SEP owner's offer. But we must not forget that the German case is about deciding, is the injunction to be granted or is it not to be granted? And it's only not to be granted if the ZEP owner's offer is not friend. In the end, it doesn't matter if the counteroffer of the ZEP implementer is even more friend. It doesn't matter because friend is a scale. If the ZEP owner offer is friend, he has a right to, he gets the injunction or the implementer accept this friend offer. But looking into the ZEP owner's friend offer, this is something that there we see shortcomings in the German case law and the lower district courts, because they say if it's not blatantly friend, not obviously friend, we just jump over this assessment and look to the implementer. And that is probably something that need to be corrected. But the German proceedings are not there to determine friend. It's not the procedural question before the courts. This is what people always have to take in mind.
The German courts also have to construe Huawei ZTE, and the question is how they should do this in a proper way.
I mean, if the ZEP implementer wants his friend terms to be taken by the ZEP owner, he can file for a DJ decision with the German courts. But this is not happening.
No.
For reasons.
Not really. So I can tell you from my practice that this has been tried and those counterclaims were dismissed for unwillingness, because the unwilling implementer is not entitled to a front license, and then it does also not have a legitimate interest for this declaratory claim. So it's not that this has not been tried in court. We will see what the UPC will do with that. There are also pending proceedings where the UPC may shed some light on front rate determination and the front obligations shortly, let's put it that way.
Yeah, I just read today on LinkedIn, I think somewhere was that the hearings in these cases before the UPC were scheduled for October 8 or 7, I think, somewhere. Well, thank you guys for this discussion. We saw that a hot topic, and we will watch very closely what the Munich Court of Appeal will do with the Amicus Curiae brief, if it will refer to the CJEU, what kind of will change. So I think there's a lot of new developments here. Will it change anything? Unsure. But maybe there will be a stronger emphasis on that friend offer of the patentee, which I would really be happy about, so that this discussion on are you willing or unwilling is a little bit reduced.
So I think that's a great way to end this webinar. My big thanks to Eisenführ and Speiser, to Vossius, to Deutsche Telekom. I understand all of our participants spoke in their private capacity. This was very exciting, very interesting. Good insights from Munich today and from Düsseldorf and Bonn. And join us for our next webinar, which is on sustainability and intellectual property, with the head of sustainability from TEVA and with a professor from, gosh, which university did I pull out from? I forgot. So she's a fellow from Said Business School, and now she's at Coventry University, I don't know. And they'll be discussing IP management, IP business strategy, and how it relates to sustainability. We are planning to make this webinar available eventually on YouTube. Please click on it. Our clicks are still not comparable to the clicks of Beyonce, for example, on YouTube. And we hope to change that. Have a lovely, lovely afternoon. Please also join us for our event in Oxford and for our upcoming event with the Unified Patent Court in Europe. Thank you very, very much again to Eisenführ, Speiser, Vossius, Deutsche Telekom. Bye-bye.
Thank you so much.
Thanks. Bye.
Bye-bye.